Picture this. You're standing at a bank counter. You've just lost your mother, and it's, an incredibly difficult time, but you're trying to step up and handle her affairs responsibly. So you hand the teller her fixed deposit receipt, specifically pointing out that your name is clearly printed right there as the nominee. You're fully expecting a straightforward transfer, but instead, the teller just shakes their head, rejects your claim, and slides over this massive, intimidating pile of required legal documents. Well, welcome to This Explainer. Today we're going to dive right into this frustratingly common and heartbreaking scenario, explain exactly why the bank just turned you away, and most importantly, what you need to do to fix it. Right now, you might be standing at that bank counter insisting, wait, but I am the nominee on the form. And hey, you're entirely correct. Your name is absolutely on the paperwork. But here's the catch. Legally, the bank cannot just release those funds to you. And this isn't just an isolated scenario either. If you walk into literally any district civil court in India, you'll find variations of this exact family dispute playing out every single day. The whole confusion really stems from a fundamental misunderstanding of what a nomination actually does.
Section 1. Nominee versus legal heir. Okay, let's shatter the biggest misconception out there right now, in like 10 seconds. A nominee is just a trustee or custodian holding the money. They are not the actual owner. The legal heir is the true rightful owner under succession laws or a registered will. See, the institution hands the asset to the nominee as a sort of administrative convenience, just so the money doesn't sit there frozen. But that nominee is legally obligated to distribute it to the rightful heirs. Think of it this way. If you are the nominee, but your sister is the legal heir in the will, you have to hand that money over to her.
So, what does this all mean for the bank? Why did they put you through the ringer? Well, the bank is legally protecting itself from future lawsuits by other legal heirs, which is exactly why they demand a formal succession certificate. They're looking for what the law calls a valid discharge. Because think about it. If the bank hands you the fixed deposit money based just on a nomination, and later on another relative shows up waving a will proving they're the actual heir, that relative could sue the bank. To prevent this, especially for large amounts, or if there's even a hint of a family dispute, the bank absolutely demands a court-issued succession certificate to definitively prove who gets the cash.
Section 2. Different assets, different rules.
Now, what's really interesting about this is how different financial assets have entirely different rules. You literally can't apply the logic of a bank account to life insurance. First up, we have fixed deposits. If there's no nominee, or if the nominee has passed away, or honestly if the bank just senses a dispute, you will very often need a court document to prove your legal entitlement, so the bank can safely release the money. And getting this succession certificate from a civil court, that can take 3 to 6 months, sometimes way longer.
But then we look at life insurance, and the rules completely flip. Life insurance policies actually bypass all this red tape, paying directly out to what are called beneficial nominees. So that's parents, spouses, or children, who then become the absolute owners. This is all thanks to a really crucial 2015 amendment to Section 39 of the Insurance Act. So if you name your spouse or your child as the nominee on your term life policy, they don't hold the money in trust for anyone else. They are the absolute, unquestionable owners, and that payout is dispute-free.
And then we get to the stock market. A Demat account holding shares or mutual funds without a nominee is the absolute worst-case scenario. It will lock your grieving family in a legal nightmare for months. While joint accounts actually have a survivorship rule where the surviving holder just gets the assets, a single-holder Demat account with no nominee freezes instantly upon death.
Just to put that into perspective, without a nominee, claiming those Demat shares can take up to an entire year and cost around 50,000 rupees in hefty legal fees. Your family is going to have to hunt down succession certificates, draft notarized affidavits, and provide indemnity bonds. And if your heirs are non-resident Indians living abroad, the process is even more agonizing. They'll need apostille documents and general power of attorney filings just to be able to communicate with the institutions back in India.
Section 3. The 2026 RBI Fast Track.
I know, it sounds pretty bleak, but there is actually a glimmer of hope on the horizon for families caught in all this exhausting bureaucracy. A brand new 2026 RBI circular creates a much-needed fast-track process for certain cases to completely bypass this red tape. This draft directive is designed to harmonize the framework across all commercial and cooperative banks.
Check this out. This new rule mandates that banks settle claims up to 15 lakh rupees within just 15 days, completely without requiring a court order or an indemnity bond. And this applies even to accounts without a nominee or joint accounts without a survivorship clause. That is a massive relief for ordinary families. And if the bank drags its feet past those 15 days, they will actually be penalized and required to pay interest at the bank rate plus 4%.
Section 4.
3 steps for easy claims.
But look, you shouldn't just wait around for 2026 to protect your family. You can empower yourself right now. Having these 3 definitive things in place would have made this entire process so easy. A registered will, updated nominations, and knowing exactly when to use a legal heir certificate. If you have these 3 pillars set up, you completely eliminate the confusion between who collects the money and who actually owns the money.
Remember, a will generally overrides a nomination for most assets, so you need to ensure they are perfectly aligned to avoid family disputes. The will dictates the actual transfer of ownership. Say your will states that your daughter gets your shares, but your brother is listed as the nominee on the Demat account. Well, your brother collects the shares, sure, but he is legally forced to hand them over to your daughter. Aligning the names on your will and your nomination forms is literally the single best way to prevent your family from ending up fighting in a district civil court.
Finally, you really need to know which document to apply for when the time comes. Securing a legal heir certificate quickly establishes your identity, which paves the way for transferring properties and other vital assets smoothly. Now, a legal heir certificate is issued by local administrative authorities, like a tehsildar, and it's much, much faster to get. You'd use this for pension claims, insurance benefits, and property mutation. But keep in mind, for claiming large bank balances, mutual funds, or debts, the bank is still likely going to demand that court-issued succession certificate instead.
Navigating inheritance laws, especially if you're an NRI trying to manage an estate from abroad, is incredibly complex. But hey, you don't have to do it alone. Send me a direct message with the word nominee to get a free, comprehensive asset claim guide that walks you through all of this step by step. It breaks down the exact documents you're going to need for every single asset class.
I'm going to leave you with this provocative thought to consider today. Really look at your bank accounts, your Demat holdings, your life insurance policies. Are your assets currently set up to protect your family's future, or are they going to punish them with endless paperwork when you're gone? Do yourself a favor. Take the time this week to check your nominations and update your will. Your family's peace of mind absolutely depends on it.